On today's episode of the Encrypted Economy, we welcome Gary DeWaal. Now, Gary is the head of Katten Muchen Financial Markets and Regulation Group. I've known Gary for years. He is a very bright person. I've always enjoyed talking legal issues with him, and oftentimes we have different views on things and we talk through it. On this episode, we talk about what to expect from Gary Gensler as the head of the SEC, the XRP case, the Howey Test, and DeFi. We talk a little bit about my notion of good coin, bad coin, or good actor, bad actor, which is a thesis I'm going to continue to refine. Now, since we taped this episode, XRP has come out with their defense to the SEC allegations, so we're going to put that in the show notes as well. And one other thing is, toward the end of this podcast, Gary started to laugh because I had failed to ask him the question about an event that shaped his worldview and shaped his values. And because we got so carried away with the discussion early on, I just completely blew it. So he told me a story, which I'm not going to try to repeat, but basically goes to how when he grew up, he was in a smaller town, smaller community, and he thought a lot of people had the same view. And when he went traveling abroad, he learned that that was not the case. He was surprised at how there were different views and different perspectives, and it really shaped the way that he approached the rest of his career and his worldview going forward. And I think I see that in all my past dealings with Gary, and even on this podcast, is he's very accepting and willing to kind of understand other people's positions, but he also has this very strong view. So listen, I think you're going to find this a very enlightening episode, and I think you'll learn a lot. If you like the show, please review it and share some feedback with me. So with that, we begin the podcast with Gary DeWaal. Welcome to the Encrypted Economy, where we look at the business of, regulation, and security for all things encrypted, digital assets, blockchain technology, privacy, and smart contracts. Hope you'll join us while we explore these forces that are shaping the economy. This is Eric Hess with the Encrypted Economy. I'm really excited to have Gary DeWaal on the show today. He was a senior managing director and general counsel for the world's largest exchange derivatives broker, and he oversaw legal compliance, financial crimes prevention, AML, regulatory developments. He was a senior trial attorney for the U.S. Commodities Futures Trading Commission's Division of Enforcement in New York. He's a professor. He's currently, a counsel with Katten Muchen. And I've known Gary for a long time. I've always been impressed by his insightfulness. He actually he did a weekly show called Bridging the Week. And it was like chock full of all this information. Like he'd get on and he would just crank out like what happened in the week, particularly across the CFTC. He cranked it out. And now you stopped that and you went from bridging the week to between bridges. So I guess what's the difference between bridging a week and two bridges and the space between the bridges?
Bridging the Week was meant to be a weekly publication, and Bridging the Week is when I get to it. And these days, it's really hard to get to it. That's the problem. But I do lots of webinars for Katten. I do lots of advisories for Katten, and I do lots of interviews like I'm doing for you. So hopefully that makes it up. And someday soon I'll retire, and hopefully at that point I'll resume Bridging the Week.
Oh, okay. Could we go to Bridging the Day?
We might. Who knows? I'm not a tweeter though, so that could be difficult.
The real time element. So Gary, it's great to have you on.
And it's good to be here. Thank you for having me.
So it's exciting. We got a lot to talk about. We talked just before this, and I was going to ask you about Gary Gensler at the end. You said maybe I should talk to you about it at the beginning. So Gary Gensler obviously is going to be the Biden's SEC chairman appointee. And a lot of people are game theorying in him. They're like, oh, he taught cryptocurrency. He's very educated in the space. He's likely to be hard, but also trying to find a pathway to adoption. So a balancing, if you will, but he's more educated in the space, arguably, than Clayton, which is not a takedown on Clayton. Gary's just spent a lot more time and energy learning about it and teaching about it and contemplating it. But what's your perspective? Because you know Gary, you've worked with him, you've had an experience with him. And so what's your view, what's your worldview of the digital asset space under Gary Gensler?
It's a good question. Gary Gensler was a very controversial leader of the Commodity Futures Trading Commission. But that being said, he oversaw the writing and implementation of a tremendous volume of Dodd-Frank rules. with a teeny agency. He effectively left the SEC in the dust as far as accomplishments in this area. The consequences were tough on the staff at the CFTC. They ultimately unionized and that caused some issues. And it was tough on the industry. And part of what Chairman Giancarlo and Tarbert had to do was fine-tune some of the Dodd-Frank rules that were enacted under Gary Gensler. That being said, at least from perception, more than actually working with him at the CFTC, he's a market structure kind of guy. He had a task. The law said, thou shalt enact Dodd-Frank rules, and he did it faithfully, whatever you think of those rules. I think what we'll see in the digital asset space is we will see some clarity. There's been much criticism over the SEC over the past couple of years because certainly in the space of ICOs, we know that because of statements of both former Director Hinman and even the chairman himself, that cryptos can morph. Both had said that Ether once upon a time could have been a security. A couple of years ago, Gary Gensler in a presentation, I believe it was up at MIT and it was quoted in the New York Times, did note that both in his view, XRP and ETH were likely today, that was a couple of years ago, still securities. So keep that in mind as you think about Mr. Gensler going forward. But I think that he is likely to say, okay, there's a lot of unclarity out there. Maybe I don't think there's unclarity because of the Howey test. I know you want to discuss Howey later on. This is Mr. Gensler speaking. But let's make sure we have a clearer line than we do today. People are claiming that it's a little confusing. Yeah, the SAFT is going to issue in a private offering. It's going to result in the delivery of a token. The folks are saying that the token is a virtual currency, but some of the courts have said, no, look at everything. They're integrated, blah, blah, blah. I think he's going to help develop some lines, okay? I think he's also going to help develop some clearer lines of when something might have been a security and no longer is. And by the way, might revert back to a security. That is the case with something already existing called security futures. Something could be a broad-based index today, could be a narrow-based index tomorrow, it could be broad-based index the next day, and a futures based on an instrument will literally move from the regulatory camp of the CFTC to the SEC/CFTC back to the CFTC. Gary is used to things that morph and change. And so I would not be surprised to see some greater clarity in the issue of certainly of what is a security. I also would expect further development in the custody regime for broker-dealers. The SEC just very recently, a couple of weeks ago, came up with the concept of a special purpose broker-dealer where the customers are only holding digital asset securities. It was a very forward step, I believe, by the SEC, but there's still lots of questions about that. That broker-dealer can't hold digital currencies, for example. And typically the folks who want to deal with digital asset securities in the first place likely want to pay for them as stable coins or some kind of other virtual currencies. And at least as contemplated today, that's not allowed. I think he'll push a lot. The other thing he will do, I think, remember, there was a fair amount of legislative proposals before year end, and they all have to be reintroduced in the new Congress to clarify jurisdiction of the CFTC over the virtual currency space, clarify, maybe implement a safe harbor as proposed, for example, like by Hester Peirce, the ICO space. I wouldn't be surprised if Gary steps back and looks at all this stuff more holistically, maybe working with the CFTC, come up with a more holistic federal approach to the regulation of digital assets and works with congressional leaders to fashion legislation to implement what he thinks is his vision. Now, that doesn't mean that the industry is going to be happy with the outcome of what these things look like. But I think that Gary could very well likely take leadership in this area. He knows the space. He understands the product. Folks may disagree with what his understanding is, but I think he will be proactive in this space. I think that 4 years from now, it will be a very different industry as far as regulatory direction than it is today.
So in drawing those lines, do you think we move into a world where you have a more clear delineation of good coin, bad coin?
I don't listen. The good coin, bad coin delineation is more in the realm of the Department of Justice and FinCEN.
We can call it favored and unfavored, meaning those that fall within the regulatory rubric, right? And aren't being delisted. I guess that could also be a Department of Justice thing, but if they're not registered securities and they're deemed to be securities.
Your background is principally securities. My background is mostly spot commodities and commodities, so I'm looking at things as virtual currencies. I think the world has been moving. Certainly 3 or 4 years ago, people talked about 3 delineated type of currencies. There were security tokens, there were utility tokens, and there were virtual currency tokens. I think more and more what we're effectively saying is there are security tokens and there's all else, okay? And the all else effectively have ambits of payment associated with them, right? So they serve some potential vehicle as either a store of value or some kind of payment token. If it's a payment on a particular platform, in the old days, that probably was considered a utility token. If it's a more broadly used payment token today, it's more likely considered to be a virtual currency. But again, I think the easier delineation is security and non-security. I think that if you go to the enforcement staff, if you go to FinHub over at SEC, I think today they believe there is a clear delineation between security and non-security. I don't agree with that. I think it's very unclear. I know we won't have time in this podcast, but I invite folks to look at some of the stuff I'll be issuing in the next couple of days. But I do think that the settlements of the ICO cases, where some of the settlements entailed a requirement to refund initial investments back to investors. Some settlements required registration of the tokens, and obviously all the settlements required compliance going forward, actually give you insight into the fact that the SEC does have a different view regarding different tokens. Not all tokens are the same, even when they're potentially once were security tokens. So I think this area, this needs to be cleaned up in regulations. People can't be going into things blind. Folks like XRP, the Ripple company, no matter what you think of what the product is, XRP, the way it's been handled, frankly, let me be blunt, I'm not shy for words, is a disgrace, okay? The fact that the Department of Justice, the fact that FinCEN could bring an action against Ripple years ago, claiming that it was a money service business and moving virtual currency in violation of AML and under the BSA, the Bank Secrecy Act. The fact that if you go to the New York State Department of Financial Services right now, there's XRP greenlisted as a virtual currency. And then just last week that the Japanese FSA confirmed that XRP is not a security. Yet here are these folks being dragged into court saying that it's a security. Again, I understand where the SEC is coming from. I understand the Howey Test, okay? I get it. But just as a matter of fundamental fairness and the fact that people have been trading in XRP in good faith as it was a virtual currency, despite what Gary Gensler said a couple of years ago, it's just too confusing. This has to be clarified.
You know, the funny thing is, Gary, to bring you on the podcast, it's like we're starting off and we've got all these boxes to unpack now, right?
Yeah. Sorry.
No, don't be sorry. This is going to be a 3-hour podcast. No, just kidding. I did want to talk to you about XRP, and you raised some really good points. And on as a last point on the good, bad coin.
Stop it with good and bad.
No, because again, the use of the term isn't me defining a value judgment. You go back to good, bad securities. There was this whole debate in the securities industry about what's a good and bad security and where do the bad securities trade. It doesn't mean they're bad. It's just a way of classifying it. And it's a worldview. And probably you're going to see this, as my guess is, more like an FATF kind of way. It's like an AML issue, to your point. It's Department of Justice, et cetera. So that's a good point. Even within the security space, the way that they treat different players could dictate what kind of settlements they get. So for example, the SEC may have a view that XRP, that Ripple that they're bad because they brought it against people. So obviously they think that something bad was done. And that settlement may be very different from where they don't think that maybe it was more inadvertent and it was effectively a good security because nobody did anything really bad. So when I use these terms, or anybody uses these terms, it's just a way of trying to bucket and try to understand the different implications. So back to Ripple Labs. So Garlinghouse and Larson didn't make their lives any easier. I get what you're saying. It was handled poorly. And I'm not making the argument that we should throw the book at them. But by the same token, you look at the Howey Test. Just because they got a ruling that you guys, well, it wasn't a ruling. They basically found them to be a currency. But you know as well as I do that agencies, that just because you got something, the Treasury Department, whoever says, hey, you're a currency, doesn't mean for a second that the SEC can't come in and say, no, you're a security. And the CFTC can't come in and say, no, there's commodities components to it. Just like you noted, things bounce back and forth and different interpretations. They were basically saying, listen, you look like a currency and you need to be regulated like a currency. That doesn't necessarily port into the fact that isn't like necessarily saying you're not a security. Now, to your point, That is confusing, right? No doubt that's confusing. XRP, they had memos, like they had counsel come in saying, hey, this could be a security. They never disclosed it. They didn't have the public disclosure that they should have had. And the SEC looks at this and they look like Garlinghouse. He's like telling people, yeah, I'm long, and he's selling. And there's all these facts that suggest that these disclosures aren't being made to the investors. And I think you look at things like Kick, for example, where it's if you're going to stick them in the eye, you're going to just say, right? What do you expect if you're going to be flagrant about it? And you look across a lot of these cases, and I don't mean to go off on this, but you look at BitMEX, you look at Kick, you look at even Ripple, and you look at the way that they're interacting with the regulators. If you're really trying to hit a globally accepted statute, you want to be treated, you have to play ball. You have to think, okay, how do I act as a responsible citizen? When you don't, you're inviting it. Now, that doesn't necessarily mean that something that is otherwise not a security is going to become a security. But what it does mean is that if you're out there and you're engaging in this kind of conduct, you're certainly more at risk for being reevaluated. And it certainly sends a chilling message through the industry. But a lot of these players, sometimes these actions create, to your point, I think is going to be your point, create bad law. It could create bad law. But what messages that send to the marketplace? And I guess that's something that Gensler really needs to figure out and correct and say, this is how we're approaching it. Because right now, for example, for securities, you have to go get a no action letter every single time, a no action letter for like stuff that is obviously not a security. But if you want to protect yourself, you got to go get a no action letter. That's ridiculous. Who's got time and the money to pursue infinite no action letters to find out they're not a security? And you look at some of these no action letters and you're like, are you kidding me? Like, why are these people spending money on these no action letters? Anyway, I've probably gone way off a little bit.
No, listen. I don't represent XRP. I'm not advising the SEC. I have no pony in the race for XRP. My issue is that the way the matter has been handled, okay, that's what I'm arguing, is just wrong. I mean, folks hold XRP. Think through the consequences if XRP today is determined a security. Think of the consequences. It probably wasn't issued pursuant to a Reg D private offering, so it's not complying with Reg D. It probably was a public offering. Since there was no prospectus, there was no disclosure, there was no registration. It means that when I sell mine, I'm effectively acting as an underwriter. And that has profound consequences for me personally. But I bought this thing in good faith. I bought this thing on a virtual currency exchange. I relied in good faith. I did my analysis and I said, yeah, it's a close call, but I think that the consensus mechanism on XRP is relatively decentralized. I know these guys are out there. And Garlinghouse hasn't been hiding under a rock all these years. I know these guys are out there. I know that they've got a fair amount of control. I see the Department of Justice. I see FinCEN. I see the New York Green List just a couple of months ago for the first time. I see abroad, Singapore, Japan, all are not looking at this thing as a security. Okay, I think in good faith this thing is a virtual currency and I'm going to trade as a virtual currency. Oh my God, it's not a virtual currency. I'm stuck with this. Theoretically, that is not the kind of outcome that we should be tolerating. And I think that's the difficulty here. I think that's the issue. And that's why I hope that Gary does implement, more clean rules, more advanced notice, and deals with this issue of what happens after the fact if something is determined to be a security that folks were relying on in good faith to be a virtual currency up until that point.
Yeah, and sure, there's always the ripple effects, pun intended. One of the things I wanted to also talk to you about, because you had brought up this notion of who's liable in the context of DeFi, and I think that's a very
No. I've done that separately. I've done that at a CFTC Technology Advisory Committee. I haven't done that here yet. I haven't mentioned the word DeFi.
But you're going to. So anyway, okay. But you just know, so there you go. But it's really important in terms of who's responsible. So you think about a DeFi project, right? And to get a DeFi project off the ground, you got to let people know about it. You got to create some interest. And today, it's the way you create interest. Everybody's a speculator in it. There's maybe a few saying, yeah, there's going to be a useful application, et cetera, and you can pound your fist and say that's the case. And I think maybe in where you have some DeFi applications that are very tied to the crypto market, that is a use case, right? Because that's the use. It's to trade crypto or what have you. But it's very difficult for a DeFi project. They have to get people excited about it. And so those efforts, Ripple had that issue too. They said, we got to raise money. Kick had that issue. A lot of these companies, they all had this issue of how do I raise money? I'm struggling. I want to do this. Now, question, was there a game plan to go decentralized? Does it even matter? right? Because initially they're engaged in this activity. So the question is, and this goes to Hester Peirce's comment, like how do we create a time period where these projects can actually try to move to decentralization without having the burden of registration, which is a very unique concept. But in the absence of that, how does DeFi get comfortable with promoting what they're doing in an environment where, first of all, they want to say it's decentralized so nobody has any liability later on, which is challenging. And number two, they want to be able to do what they're doing without necessarily having to worry about being seen as a securities offering, but yet their efforts and their ability to convince people that this is a profitable enterprise is really dependent on what they do initially. Answer that question in complete form and we'll be good.
Well, spot on. From the days that I was a junior attorney at the Commodity Futures Trading Commission back in the early 80s, there was always a cardinal principle of regulations. And I mentioned this during a presentation I made, as I said, before the Commodity Futures Trading Commission on behalf of the Technology Advisory Committee Subcommittee on Virtual Currencies a couple of weeks ago. Regulators basically say, same business, same risk, same rules. And what effectively that means is regulators are technology neutral. They couldn't care less about the technology that's used in an endeavor. They couldn't care less about the form of the use. What's relevant is what's fundamentally being done. And if it fits within one of the existing boxes, then it's a problem. So just because you call yourself decentralized, just because you call yourself anonymous, doesn't mean that you're not subject to the same law and regulation. You may call yourself a decentralized exchange. The smart contract may be an automated market maker of some kind. You may be pledging pools of assets and getting these things called governance coins in return. And you may then just sit back and you're effectively yield farming. You're looking to see what are you getting out of this for your pledge. But at the end of the day, the problem is that when folks come in because they want to do some kind of transaction on a decentralized exchange or that aggregator or whatever, there's transactions occurring on an organized platform. It may be a decentralized organized platform, but it's some kind of organized platform. If you're dealing with virtual currencies, you're potentially touching money transmitter rules. You're potentially touching MSB requirements with FinCEN, the money transmitter rules at the states, maybe the New York bit license issues. If you're somehow involved in the governance of this and you're getting evidence of your involvement in the governance, are those governance tokens securities somehow? I don't know. But the problem is if the regulators say this DApp, this exchange, this decentralized exchange should be licensed, the next question is, okay, what do we do about it? You can't sue source code. makes a really lousy caption for an enforcement action. So you can't sue source code. And if the DApp and the smart contract were all set up correctly, you probably had some anonymous programmers developing the code and posting it. And if they were smart, they were absolutely making sure that they weren't compensated for it. So you have arguable First Amendment rights to shield those guys. So the problem then is who's liable? Who is the SEC or the CFTC or the Department of Justice or any regulator going to sue? What concerns me about the DeFi space is that bad facts make bad law. The regulators, they're going to get frustrated. Since they agree that source code makes bad captions, they're going to start looking for more theories of secondary liability. Now, you're right. Where there's a programmer, where there's somebody clearly identified with the project, and there's someone clearly a promoter, like the SEC brought a case against Zachary Coburn in connection with Ether Delta a couple of years ago for the Ether Delta platform, which is effectively a DeFi exchange. It's easy. And when the DeFi is constructed, I think it's not so easy. And then the question is, who's going to be left holding the bag? I think you're going to have expansive theories of secondary liability. Now, as a lawyer, I would say I would take those cases on because I don't think it's going to be so easy to get a court to agree with some of the theories of secondary liability. But that doesn't mean it's not going to be costly to defend those actions. It doesn't mean it's not going to be costly to have to deal with your lawyers, producing documents, deposition. It's definitely going to have a chilling effect. And sure enough, there will be a court here and there that will hold for an expansive view of liability. It's inevitable. And by the way, even if the regulators lose, they'll just go back to Congress or they'll go back to their state legislatures and say, hey, we need to plug this hole. So it's just a matter of time. Maybe it'll be slow for the law to catch up, but it's a matter of time before secondary liability theories are expanded to potentially capture people associated with DeFi. The Department of Justice is not going to tolerate North Korea or Cuba being part of a liquidity pool. End of story. And they will do anything they can do to prevent that.
Some tokens, they're
Yeah.
setting up like pooled insurance funds. That's sort of part of the overall, I guess, governance structure that they're taking some component in reserves and that can be distributed based on, I guess, if there's like a liquidation. In other words, it doesn't necessarily plug against bad acts because if the bad acts could be somebody absconding with it, which is any company.
Yep.
But the insurance does provide some of that protection. And it suggests that it's a more responsible way to view some of these DeFi projects where if something blows up, people lose money. How do they bring an action? Now, that's not necessarily a securities issue per se, but yet if they were led to believe otherwise, then who is responsible for that? So do you think these DeFi projects setting up like these pooled insurance funds, they could even be DeFi insurance funds, do you think that's a direction that starts to get explored more?
Listen, there's definitely talk more and more in the DeFi space of interacting with Oracle so you can do some kind of cursory or at least some kind of AML, some kind of KYC. It begs the point. You can always volunteer to comply with the Bank Secrecy Act. But I think FinCEN would effectively say, again, this thing is an exchange, or this thing is acting in some kind of money transmitter role. Therefore, it needs to be licensed as an MSB in the first place. It is not licensed as an MSB. So sure, it's better that it's following BSA requirements, but there's some BSA requirements it's not following. Now, whether ultimately the regulators want to come up with some kind of safe harbor where if you follow all the things, if the programming allows this, then the technical registration will figure out some way of qualifying you, even though you're just a source code. Begs the imagination, and there are potential solutions. But again, bottom line, if North Korea or Cuba or Iran are part of the liquidity pool, the Department of Justice isn't going to tolerate that. They'll find a way to deal with it. They may lose, but my guess is particularly going forward, they will be aggressive in taking their chances to make a point, even if they do lose.
And that goes to, again, FATF and Lagarde in the EU, and you see even Yellen in the US talking about, are these coins being used for illicit transactions?
She said that in her confirmation hearings yesterday. She talked about that.
Yeah, so she underscored it. So I think there are battle lines being drawn. I think, to your point, again, going back to good and bad coin, it's less of a securities issue, or it's really more of an AML FATF issue. And it's like, how do you enforce that throughout? And I do think it's an interesting world. I really want to do an episode just on AML and FATF and really dig into it because, you look at a lot of these privacy coins like Monero, for example. Somebody just was asking me about Monero last night, and they've got delisted, they've gotten hacked, but yet they're also crazy scalable. And they're actually more cost effective than Bitcoin, but they'll never, as long as they have these features in them, they'll just never, they have no on-ramp.
They have no on-ramp, and the Attorney General's the report they issued late last year on cybercrime and in the digital asset space, absolutely, I had one takeaway from that. I actually thought most of the report was nothing new, but twice in that report, they talked about the anonymized coin, the Zcash, the Monero, as a real big issue because they're just so anonymized that it's hard for law enforcement to get their handle around transactions involving them.
So, Gary, you handed me my segue. You didn't even know it, but now I have to go into it. It was like another thing I want to talk to you about is the integration doctrine. So what I thought, there were a number of things I underscored in that report. I think anybody who's serious in the space from a legal perspective needs to read that report because it does suggest a much more an effort to have a lot of agencies working more closely together on this. And it gets to, you don't want fractionalized regulation. You don't want fractionalized enforcement. You want some consistency and a recognition of where the lines are drawn. But one thing that I noted in the report that stood out to me, in addition to what you said, and a few other things, which I won't get into, they say, FinCEN has observed, and the BSA applies to entities and individuals that engage in money transmission as a business and that operate wholly or substantially in part in the United States, regardless of where they are incorporated or headquartered. That's a truism, right? Of course.
Absolutely.
Having said that, you see this notion of integration in BitMEX. BitMEX was a perfect, to me, integration case. Like BitMEX said, hey, we're over there. We just have some operations here. And the AG and the CFTC said, no, you got a lot of stuff going on here. You're doing a lot of the work here. And I don't care if you're integrated somewhere else. We're still holding you liable here. And you take the BitMEX case, and okay, and they lay out the facts, and it's very persuasive. And there's a ton there. One of them is what they did with the IP addresses, which was you breach that line a couple times, or you instruct people on how to get past US IP address. But you're hosed. I'm sorry, that's a rough one to get over, right? Like you're going to play the IP address game, and you're going to give specific advice. The minute that email goes out, oh my God, you've just set off a time bomb. But anyway, listen, alone that may not be enough. There may be a ton of other things going on. But what was interesting about BitMEX is what kind of message it sends to the market. If I have some operations in the US and I'm doing an exchange based overseas, what does that mean for my operations in the US? Obviously, you have to comply with the laws. You're still potentially regulated. So you might have set up your base of your operation maybe offshore, but as you try to toe in and try to facilitate some things in the US, even developers, you potentially run a risk. I don't know what kind of dynamic that creates and whether that's the right dynamic. What do you think?
Listen, where's the DApp? Where's a decentralized application? Is it in the United States? That's going to be one of the first threshold issues that are going to, not only do you have the issue that you're suing source code, but you're claiming they're a U.S. person. And I think that most of the entities approaching the DApps are not doing it through their U.S. entities. They're doing it outside the United States to begin with. So do any of the U.S. regulators even have jurisdiction? So yes, I agree with you. I think that certainly as alleged in the BitMEX case, there was a substantial presence in the United States. Yep. There was substantial efforts in the United States. There was an outreach to U.S. persons. One of the principals was actually arrested in New York. So yes, the company was organized in the Seychelles. But I don't think that the nature where a company is organized is what drives something. It is the evidence of presence. And I think that's a facts and circumstances situation. And folks will argue that they had minimal contacts with the United States, not sufficient to be considered a U.S. person. And the CFTC and the Department of Justice will argue absolutely otherwise. And I think that that's going to be continuing the case. I don't think that where somebody is incorporated is as relevant as where you're conducting business from.
But it certainly makes the fact that the Justice Department is raising it, the way that it's raised in the BitMEX case, the way that it's raised in even like Kik, it's framed in such a way that it doesn't suggest a natural limitation to it.
And it completely breaks down to DeFi. I hear the argument, but it's an evolutionary concept. Once we went global, folks are arguing all the time that they don't have a U.S. presence, and it becomes a facts and circumstances debate in pleadings and in the court as to whether that's true or not.
So to get back to the Howey test, just in terms of how do we define what a security is going forward? Obviously, the Howey test was based on a citrus farm. And basically, it relates to the sale of an interest, whether there's an expectation of profits through the efforts of others, solely through the efforts of others. And that's the short form of it. And that often determines whether or not a token is going to be classified as a security net. It was based on a sale of an interest originally in 1946, based on a sale of a citrus farm. So, Gary, knock, knock.
Who's there?
Orange.
Orange who?
Aren't you glad that your token project is not a security? So so I just lost a few subscribers there, but I
probably did.
I think I did. So anyway, as we go forward, like with Gary Gensler, do you think he's going to take up the Howey test and you think he's going to refine it? You think he's going to largely stay with it? What happens to the Howey test going forward? Is this going to be the governing law? Is it going to be interpreted through additional guidance? What's your thinking on that?
I don't think Howey fundamentally is going to go away. It's entrenched. It's the law. I don't think the Supreme Court is going to overturn Howey at this point. And again, I think the SEC has tried hard to educate folks on what how it applies Howey certainly in connection with a plain vanilla ICO. My issue is where it gets a little more complicated. It's the nuances. There are folks who do the simple agreement for future tokens, and they acknowledge that SAFT or SAFTI is a security. And they do what they need to do to sell it only to accredited investors. They comply religiously with Reg D, and they think they're home free. Where things have gotten nuanced is now you have the token distribution event, or you do have some kind of general public ICO down the line. And the SEC is saying not only is the SAFT or the SAFTI a security, but so is the crypto asset that's issued as a result. And by the way, since the crypto assets issued to the initial private investors is the same crypto asset that's being issued in the more general distribution, we're telling you that we consider those two offerings integrated, and the private offering really doesn't qualify in the Reg D because it's a public offering. Okay. That kind of nuance is problematic. I mean, and I do think that some of the people who criticize that approach are right. Companies drill for oil. They're publicly traded companies. Their securities are registered and people buy and sell them. The companies themselves may promote oil. They may do all sorts of things to make oil seem more valuable. I'm not sure that makes oil. In fact, I'm pretty sure that doesn't make oil a security, because people are promoting the product that's being developed. And I think that's a nuance here that's a little difficult, because no one really thought about the products of publicly traded company as securities in and of themselves, but the logic of the SAFT versus the distributed token debate, it raises that issue. And again, bad facts make bad law. If you start saying that every product, so to say, drilled as part of the initial security is also a security, you're opening the door to all these made commodities or produced commodities are also securities. I don't know where that goes. Clearly, there has to be some delineation. So it's the nuances that I think are trickier at this point. I think those are far more compelling in need to be addressed than the fundamental Howey decision.
And you even have cases like Tomahawk, which raises questions about where there's an airdrop of a token, and that was deemed to be a security. And there was no value exchanged. And you could say, well, that's fact specific, but all these facts just make figuring out where you fall on the scale that much more difficult.
We all thought that the investment that you needed to make was fiat currency. We learned early on that the investment could be in ether. And now we're learning that the investment could be human services, human capital, bounty programs where folks didn't think they were actually making an investment. Turns out that the regulators think they did make an investment. But it's the same thing, expectation of profits. No one's getting dividends. No one's sharing the income of the enterprise. It's the appreciation that comes about theoretically by secondary market transactions that's considered to be the profit that you're expecting. So again, there's nuances that fall out of Howey. And in fairness, they come out of established case law. But I think those are the kind of things that need to be clarified. And again, my concern is I do think clarification will likely happen within the tenure of Gary Gensler. I'm not sure the industry is going to like where those boxes are drawn.
I think it's going to be the age-old tale of those that are in position now. They're in pole position. Like you have Coinbases, you have Genesis, you have Grayscale. You have a lot of these becoming more institutionalized players. And they're going to have the resources and the ability to comply with the new regime. And then the real question is what does it do for innovators and new projects? Because the DeFi space, in large part, it's a sandbox, and a lot of the innovations could be very impactful. But there are entrenched interests that see disintermediation of what they have. So what might happen is you might bring in some of the institutional players that are on top now, and you may end up crushing in the process the innovators that are trying to build, because now you have an order that is threatened, right?
Hey, listen, Satoshi Nakamoto, the basic concept of Bitcoin, the blockchain, was to have a disintermediated infrastructure, particularly in finance. That's not what happened. Very quickly, it became intermediated. When I spoke at the Technology Advisory Committee a couple of weeks ago, one of the things I said is, because there's an argument that some folks want a sandbox for DeFi actors so we can sort this thing out without people feeling worried about secondary liability. But the argument against that is that discriminates against the brick and mortar early entrants in the crypto arena that actually paid money to comply with existing regulations. So they would be disadvantaged because they spent all that money trying to comply with the rules, whereas folks would be given an opportunity to effectively, operate without a lot of considerations for some of the rules in some short period. That's the theoretical argument against sandboxes in general. It does come to play here.
And I guess that's where Hester Peirce's argument comes into play, where you need to encourage that innovation. And the fact that some people suffered under the prior lack of clarity. I mean, XRP could find themselves on the other side of this and right the ship. It's going to be hard because they're trading, 20 cents. And that's probably a lot considering what's going on. Maybe they or Monero or some others could find ways to reinvent themselves. And then they could say, listen, we spent all this money to reinvent themselves. We spent fortunes. We look at what we suffered. If XRP is on the other end of this, they'll probably end up becoming one of the primary proponents of regulation.
Sure. Right? Listen, governments are looking forward to enter into the stablecoin business. They want to have fiat central digital currencies. Even Gensler, at the time that I believe it was the same speech where he talked about XRP and ETH being potentially securities, talked about the power of the blockchain. He is a proponent of the technology. Most of the folks who are critics of some of the actors are very strong supporters of the technology. So the question is, how do you punish people who you think are somehow exploiting the regulatory ambiguity, yet not discourage people from taking advantage of this new technology and making it even better and stronger? That's the challenge here. That's going to be the real challenge.
On that note, so 2021, what are your predictions?
Hard to say. This is just such an unusual time. I can predict that virtual currencies and virtual securities won't go away, that we'll be having these debates and discussions way within 2021, that there'll be more enforcement actions. So I think there'll be a lot more of the same. But I do think that once Gary gets his team in order, you will start seeing some movement for clarity.
And so on Gary again, or I guess I should say Chairman Gensler, because I don't have that first name basis with him. So you can say Gary. I
can say Gary because I'm a Gary.
Yeah.
There's not that many Garys in the financial services industry.
But I'm definitely not on a first name basis. So
you're not Gary. Sorry.
I'm not Gary. So I don't have that.
Right.
But is this going to be one of his top priorities? Obviously, he's got a full plate. But in terms of his priorities, where do you think this ranks?
That's a real tough one. I think the whole focus of the SEC is going to be changing more to customer protection. I think that's what most of the analysts are talking about, whereas the prior emphasis was really on opening up Wall Street to Main Street and granting greater access. I think the SEC will be turning direction. That being said, I've never been a believer, even though I thought that a lot of the Dodd-Frank rules promulgated by the CFTC under Gary's regime were a bit too strict. He dealt with the hand he got. He had to do things. He did it. And he did it the best way he could do it. And I think he recognized that over time, there probably had to be some tweaks. And frankly, had he been in power during the last 4 years, I wouldn't have been surprised if he would have made some of the same tweaks that Chairman Giancarlo and Chairman Tarbert did or led. I wouldn't have been surprised. Maybe not with the same force or momentum, but certainly some of it. Because it was just natural. Once you saw the thing work, you realized that there were some problems that had to be addressed. I do think crypto will be a priority for him. I don't know where it will be on his chart. I do think better coordination with the CFTC. Chairman Tarbert and Chairman Clayton made good strides in that. I think Gary will accelerate it no matter who is ultimately nominated and appointed chairman of the CFTC. And I do think that this issue of whether some elements of the virtual currency space should be preempted will be dealt with. That's not an SEC issue. That's a CFTC issue because CFTC does have preemption in many areas where the SEC does not. But I do think that Gary will participate in that conversation.
Great. Gary, so glad to have you on the show. So before we break, if people want to learn more about you, what you're writing, what you're involved in, where can they find you?
I'm hiding in a cave in Colorado up on a high mountain.
There you go. So you have to do smoke signals to reach Gary.
I may be physically distant, but I am still an active member of the financial services community and very proud of the practice that I lead at Katten and the good folks I work with here. They're really terrific. And I'll leave you with a teaser. We've got a great hire we're going to announce next week.
Oh, okay. Wow. I don't know where to go with that one. Hints? No.
Nope. No hints.
And you said you were going to be releasing some papers, webinars, some other.
Yeah, we've got I don't know when this podcast is being published, but we have a good webinar coming out on January 21st. It's going to be an overview of the crypto developments of the last quarter of 2020 and the first week of January, which actually had a fair amount of developments. Again, I don't know when this podcast is out, but we will be posting a tape of that webinar. It's a video webinar online, and it will have a nice brochure that has my analysis of a lot of these developments in writing.
There you go. So by the time we do this, we'll actually update the intro. And so send me the link. We'll include it in the intro.
All right. Terrific.
Thanks for coming on.
Okay. My pleasure. Have a great day. And to everybody, be safe.